Welcome to this Farm Advisory Service webinar on passing on your croft. We're going to give you lots of information about how to find out what your options are, what your status is, and how to get started on a succession process. I am Osla, based up here in Shetland at SAC Lerwick, and I will be helping to facilitate this meeting. We have some excellent speakers for you tonight, and there will be a chance to ask all your questions as we go through. If I could ask you either to pop your questions in the chat as we go through, or also if you want to raise your hand, either electronically with the raise your hand button, or you can do that also just physically, wave at us and we will see you eventually. Okay, but please do make sure that you ask your questions. There'll be plenty of time at the end to ask questions, but also if you have anything burning as we go through because it's not clear, then please do jump in with a question. I've said about recording. Unfortunately, we don't have our crofting solicitor with us tonight because of personal reasons. She wasn't able to come, but we still will look at crofting wills and power of attorney, and we have lots of free resources to share with you as well. So we will be covering that as well. We do have Graham Fraser with us, who is based in SAC in Lerwick as well, and he has almost 40 years of experience in crofting regulatory work. So there are few people in the country, I would imagine, placed better than him to answer your questions. And we're also very lucky to have with us two development workers from the Crofting Commission, Lynn Henry and Karen McRae. Don't know if you want to wave. And they will be very happy to answer questions as well, and also to share with us some of the work that the Crofting Commission is doing on succession materials and supporting folk that are looking to make those all important decisions on how and when to pass on crofts. And myself and my colleague Jane McPhee, who's based in Stornoway, will just be helping to field your questions and just facilitate as well. So without further ado, I shall pass over to Graham, who will share his screen and get started on the main presentation.
Thanks, Oslo. Yeah, I've got a presentation I'm going to run through. We'll try and answer as many of your questions as we can, but as a lot of you are probably aware, crofting regulation can get pretty complicated. So that you might come up with some scenarios that we maybe can't quite get an answer to you tonight. But if that's the case, we'll try and follow that up. So I'll try sharing my screen. There we go. Right. I hope it doesn't move on an extra one. Right. So I suppose the first thing, before you know how you can pass on your croft, how to go about it, you really need to be sure what type of crofter are you, because there's quite a few different possibilities on the crofting register. So you can go to the Register of Crofts. You can just Google the Crofting Commission, take you to their homepage, and there's a search, the Register of Crofts button there, and you can go in and you can search on the croft name. You can search on the registration number if you know it. You know that usually is a four-digit number starting with a letter. So for Shetland, for example, Z for Zetland, and for Orkney, O for Orkney. So it depends on what area you're in, what letter your croft number will start with. But you select from the drop-down box that you want to search on the registered number, and you put in that number, and it should take you straight to that particular croft. You can also search on the individual's name, the whoever is the occupier, the tenant or owner occupier or whatever. Spelling, hopefully the names would be spelt right, the individual names, but sometimes the spelling of the croft name can differ from what you expect, or even the name can be different from what you expect. So if you can't find it with the name, try a different spelling. If you can't find it with that, try the tenant or owner occupier's name or landlord or whatever, and that should hopefully take you to you might get a list of crofts, and then you have to kind of find the right one. So once you've found the right croft, then that should give you the status of the individuals involved who are related to that croft. So if there's a tenant, it'll say they're the tenant, and then in that case you would expect it also to list the name of a landlord or landlords. If they're an owner-occupier, it will say owner-occupier on the Register of Crofts. Or one other possibility is it might just say that they are landlord and there's no tenant listed. So the Crofting Commission usually refer to that situation as someone being a landlord of a vacant croft. And I'll come back to that in a minute, in a few minutes. And of course, you can have, in addition to there being a tenant, you can also have a subtenant. And in addition to there being an owner-occupier, you can also have a short-term tenant. So those are people who have been given the use of the croft for anything from 3 to 10 years, and they take on the sort of rights and responsibilities of the crofter during that period. It makes them eligible for crofting grants, for example, but they don't get any security or long-term occupancy of the croft. It'll come to an end when the period that was agreed to comes through. So there is also, in addition to the Register of Crofts, there is, since 2013, November 2013, the Scottish Government introduced a Crofting Register, which is a map-based register. While all crofts are on the non-map-based Register of Crofts, then you're not necessarily going to find all crofts on the map-based register, because it's only those that have been registered that will be there. And that can be done on a voluntary basis or when there is a trigger event. And that link, which we'll put out in the email at the end of the webinar, that link would take you to details of who and when needs to submit a registration. So it's usually things that need the Crofting Commission approval. So if you go to assign your croft or decroft a house site, then those things require the croft to be registered. Giving somebody a sublet or giving somebody a short-term let don't actually trigger registration. And if the croft isn't registered, a change of landlord doesn't necessarily trigger registration, but a lot of other things do. So that link will take you to a list of where and when you need to register your croft. And there's also guidance on the next link takes you to guidance where you can find out how to produce a suitable map for registration and what forms you need to fill in, and the forms are accessible via those links. So I suppose the question is whether you want to leave, if you're thinking about how you're going to pass on your croft, you have a basic choice, I suppose, is that you either do it when you're no longer here, you leave a will that specifies, for example, a tenancy that's to go to a particular person, and then if you've done that in your will, then that's called testate succession. And if you have, if you've passed on and you haven't left a will, or the will didn't adequately cover the transfer of the tenancy or tenancies, then that's called intestate succession. And testate succession is usually significantly more straightforward than intestate succession. And when maybe going back a wee bit where I was talking about searching on the Crofting Register, the other thing you need to check on is how many crofts do you occupy? Because a lot of folk, we regularly get folk coming into us and saying, I want to pass on my croft. They think it's one croft. They have only one business with ARPID. They only have one code number, but they have forgotten or never realized that behind one business and one code number, there can be several crofts that they inherited from their predecessor. So you need to check whether, if you are dealing with a succession of tenancies, is it all one tenancy of one croft, or is it several tenancies that you need to refer to in your will? Okay, so the time scale, there are time scales associated with the different types of succession to a tenancy. If you have to send a notification form to the landlord and a copy of that to the Crofting Commission, and if the croft isn't already on the register, the map-based Crofting Register, then you also need to submit the Form A first-time registration and a check for £90 and along with the appropriate maps and supporting information such as decrofting orders, if there's any decroftings that have happened within the last 20 years, etc. So that you have to do if it's testate succession, i.e. you've got a will that specified the tenancy of the croft was to go to an certain individual, then you have to notify the landlord within 12 months and a copy to the commission. If it's intestate succession, so it's basically the executor deciding who the most appropriate person to pass the tenancy 2 is, then you have a bit longer to deal with that. You have 24 months to do that. Now, there was a land court hearing, I believe, not that long ago, within the last few years, where somebody was trying to pass on a tenancy by intestate succession well after the 24 months. And I think initially they were sort of told they couldn't do that, but I think it was an appeal. And eventually it was decided that as long as the landlord hasn't notified the commission that he's declaring the croft vacant, then the intestate succession can happen many years after the death of the previous tenant. So there isn't a sort of absolute cutoff at 24 months. But if you don't manage to do it within 24 months, you are potentially putting the tenancy at risk in that the landlord could decide to declare the croft vacant. So I think you ideally want to get on with it as quick as you can. What delays it very often is waiting on confirmation of the deceased estate. So the intestate succession form asks you by what method you're transferring the tenancy, and it's usually by what's called a docket, which is a form filled out by the executor passing on the tenancy, and it asks for the date of confirmation of the deceased estate. So that's usually the hold-up, is particularly if it's a large and complicated estate, if they've got lots of crofts or there's other businesses and things that have to be wound up or valued, then sometimes it can take quite a long period to get confirmation from the courts for the value of the estate, and you can't really do the intestate succession until that happens. So it can't very often be either close to or beyond the 24 months when folk are getting this done. Okay, I don't know, Oslo, are there any questions on the tenancy succession before we sort of move on to owner-occupiers?
Not that I've come in so far, Graham.
Okay, that's fine. They can still ask questions on that. We can come back to it.
Yeah.
So owner-occupiers, again, you've got a choice of whether you want to do it within your lifetime or whether you're just going to leave it to be covered by your will. So if you want to do it within your lifetime, then it's basically the first step is the title has to be transferred from you to whoever the new occupier of the croft is going to be. So it's basically speaking to your lawyer, getting their advice, and once the title transfers, then the new owner of the croft notifies the Crofting Commission, and if the croft isn't already registered, they have to then register the croft boundaries with suitable maps, putting in all the supporting documents required, and that's a Form A and a cheque for £90. If the croft is already registered, then they will be asked for a Form B and a cheque for £90 to update the register to show the new owner. Now, when titles transfer, there's also land registry in addition to croft registry. Now, land registry used to be voluntary, but did become compulsory. I think it was I'm not sure, about 2015, I think. So any transfers of title have to go on the land register these days. And if it's a first-time registration of a title on the land register, that can take a considerable time. And folk find that it's often a year or more before they get their land certificate back from the land register. Now, you don't wait for that. The official sort of day that the ownership changes is the day that the previous owner signs the disposition. So the day they sign the disposition disposing the land to the new occupier, that is the date title transfers, and that's the date that's required for the form to notify the commission that there is a new owner occupier. will. So if you're not want to do it within your lifetime, you just want to continue to occupy and be owner occupier of your own croft, then you can just cover it in your will that the title to a particular croft. So if you have more than one croft, you can leave it to different people, different crofts to different people. You can specify, but you have to specify that that croft A is going to pass to your son or whatever, and croft B is going to pass to your daughter. You know, it all has to be properly named in your will for that to be an effective will. So, and again, the registration would be as in the first case there. If it's not already registered, it'd be a Form A and a first-time registration. If it's already registered, then we need a Form B to update the registers to show the new owner. So where you're an owner occupier and you're passing your croft on to the next generation or to somebody else, then as long as there's a single title deed for the entire croft, so that can either be one person owning the whole croft or two people owning the whole croft between them, then the new occupiers will also be an owner occupier or owner occupiers. What you can't do is if it's one croft and you leave half the croft to your son and half the croft to your daughter, they will not be owner occupiers because owner occupiers have to own the whole croft. So in that circumstance, you'd be making your son and daughter landlords of a vacant croft on the register of crofts, or what the crofting register calls owners rather than an owner occupier. So you need to think very seriously whether you want to do that. If you were wanting to leave bits of the croft to different people, be it a son or daughter or two sons or whatever, then it would be advised to apply to divide the croft before you leave that in your will, because otherwise you're ruling them out of any eligibility for crofting grants, because only tenants and owner occupiers, subtenants and short-term tenants get the crofting grants. Landlords stroke owners don't get the crofting grants, so you don't necessarily want to leave them in that circumstances. So if you're landlord of croft with a crofting tenant, you can also leave your landlord's interests either by transferring title to a new landlord with the help of a solicitor, or again, you could specify in your will who your landlord's interests were to pass to. If the croft isn't already registered, then a change of landlord doesn't trigger first-time registration. But if the croft is already on the map-based crofting register, then a Form B and £90 will be required to update the register to show the change of landlord. So as I said, you on the registered crofts, you might be classed as landlord of the vacant croft. I don't think it actually says landlord of the vacant croft. I just think it says you're landlord and there'll be no tenant listed. It'll say that the tenancy is vacant or there's no tenant, none. So if that croft is on the crofting register, the map-based crofting register, then they call that an owner as opposed to an owner-occupier. The owner-occupiers, the status of owner-occupier didn't exist until I think it was the 2010 Crofting Act. Prior to that, folk called themselves owner-occupiers, but it had no sort of legal status. And the 2010 Crofting Act then defined an owner-occupier as somebody who had been tenant at the time when they took title to the croft. So either they were tenant and they bought it off their landlord, or they were tenant from a family member and the family member left them title in their will. So as long as they were tenant at the time when they took ownership of the croft, then they got this status owner-occupier. And when that was introduced, they did away. There used to be owners could potentially get crofting grants by passing a means test to show that they were of like economic status to a crofter. But they did away with that, and now tenants and owner-occupiers, and also the subtenants and short-term tenants, but tenants and owner-occupiers have the same eligibility for grants as each other. So there's less, before this legal definition of owner-occupier, there was a slight disincentive to buying your croft and becoming owner-occupier, because you then would have to go through the means test before you could be sure before you could get eligible to the crofting grants. But now that's gone, and if you buy your croft, you're still going to get the same grants as a tenant does. So how, there's quite a few scenarios where folk can end up as landlord and owner rather than owner occupier. So we've had cases in the past where somebody bought the croft off their landlord, but they then decided to put a son or a daughter in as their tenant. But after a few years, the son or the daughter decided they were no longer interested in being a crofter, and they relinquished their tenancy. And in that case, the person who had let the croft to them is then left as landlord of a croft with a vacant tenancy. And if they sell it to someone else, that person would be the same. They would be landlord of a croft with a vacant tenancy, or owner, as it says on the crofting register. And then another scenario is maybe a title of part of the croft has been sold without being decrofted. So the ones I've come across on that are, for examples would be Scottish Water that bought a bit of land off a croft to put a pumping station and a water tank on, and they never decrofted it or resumed it. And so they were joint owners of the croft, and the individuals were then left as landlords of a vacant croft. And in that particular case, the problem that caused was those owners wanted to divide their croft. It was a large croft, and they wanted to divide it with a view to selling part of it and retaining the other part. But only tenants and owner occupiers can apply to divide a croft. Landlords of croft with a vacant tenancy, or owners as the crofting register calls them, cannot apply to divide a croft. So we had to get the whole thing sorted out with Scottish Water and get the bit of land that they occupied decrofted, so that they were no longer had any interest in the ownership of the croft. At that point, my clients reverted to being owner occupiers and then could apply to divide the croft with a view to selling it. So this landlord thing can be an issue. Landlord of a vacant croft can be an issue. Another one was, and that one's not been sorted yet, but another one was British Telecom own the land under their exchange, which was built on the croft many moons ago, and the land was never decrofted. And they're listed on the register of crofts as joint landlord with my client. So there's quite a few circumstances. We've had ones as well where this is going back to the days where owners had to go through the means test. And so rather than opening them up to have it themselves to having to go through the means test, this was maybe 30 years ago, rather than the tenant, in this case the wife, buying her croft off her landlord, her husband went to the estate and bought the landlord's interests and became her landlord. So that was fine, that worked away. She just remained tenant. She got any crofting grants she needed, but unfortunately, she then passed away. And because he can't be his own tenant, he couldn't succeed to the tenancy. So he was then left as landlord of a croft with a vacant tenancy. So there's lots of different circumstances where this can arise, but you just need to check the register and check your status to know whether or not this applies to you. As long as you're listed as tenant or owner occupier, there's no major issue. Now, if you do find that you're landlord of a vacant croft, you can still transfer your interests during your lifetime by transferring the title via solicitor. You can specify in your will that the title to the croft is going to pass to a specified person or persons, and in those cases, those successors would still be landlords of a vacant croft. Another alternative is to let the croft to your successor during your lifetime, and the change of landlord wouldn't trigger registration of a croft if it's not already registered, but if it was registered, you need a Form B. But letting the croft to your successor, your son, your daughter, whoever you're wanting to get the croft, would definitely trigger registration if the croft wasn't already registered, or require a Form B and £90. And that then makes them your tenant. And if you then let the croft to your desired successor, you can then leave title to the croft, either you could leave title to another person, which would mean that successor would remain tenant of the croft, and they would have the normal crofting rights with the right to buy that croft from their landlord, unless you had excluded that right when you set up the new let. When you are creating new lets, there are sort of four things that you can exclude from the statutory conditions of let. And those are the right to assign the croft, the right to buy the croft, the right to benefit from the sale of any house sites by decrofting, or the right to benefit from any resumptions. You know, if the council came along and did a road widening and took a bit of land off you and compensated you, then you can retain that money just for the landlord, and the new tenant that you've let it to doesn't get those rights. What you can't exclude you can't exclude any other conditions of from the statutory conditions of let, unless you go to the land court. You have to go to the land court to get it varied, and you know, so you can't exclude for example, the right for them to have a successor when they're no longer here. You know, so it's not just a lifetime tenancy you're giving them. They potentially, if they left a will, they could leave. Well, even intestate succession, that the tenancy could then pass to a successor on their death. So it isn't like you're giving them a lifetime rent tenancy. But if it's a person you're wanting to succeed to your croft anyway, then you can you can make them your tenant, do a let, and make them your tenant during your lifetime. And then, if you wish, you can specify in your will that the ownership of the croft is to go to them when you're no longer here. And on that point, because they were tenant first and then got ownership to the croft, at that point they then become owner occupier. So can be quite a good way if you've ended up in this sort of awkward circumstance where you are landlord of a croft with a vacant tenancy, then letting the croft first to your planned successor can be quite a good way of sorting that and getting them back to being an owner occupier when the title passes to them, again, either during your lifetime or in your will. Yes, and owner, landlord of vacant croft. So as I said, sometimes the reason that you're listed as a landlord of a vacant croft or this owner is because you don't own the whole croft. Either someone else, the British Telecom, Scottish Water, or just another individual owns part of the croft. And if you're a landlord of a croft with a vacant tenancy, because you only own part of a croft, then letting the part of the croft you own has the same effect as applying to divide a croft. So, assuming the commission approve the letting, then that would split the bit you own from the rest of the croft and create a new separate entry on the register. If the croft isn't before you start this, if the croft isn't already on the crofting register, then this letting part of a croft would trigger registration. You'd have to do a Form A, £90, submit all the maps and decrofting orders or apportionment orders and things like that, if applicable. And that £90 you pay would cover the setting up of the splitting of the croft into two, your bit and whatever the other owners own on the register if and when the commission approve that letting. And again, if the croft was already registered, and what you're registering at that outset point is the whole croft, not just the bit you own. You have to register the whole croft first, and then it gets divided on the register as and when the commission approve the letting of part of the croft. If the croft was already registered, then a Form B and £90 would be required if the letting of the part of the croft was approved. So again, if you are in the circumstances where you don't own the whole croft, that can be quite a good way to sort the issue and just let what you own to a family member. And again, then if you left it to them in your will, then at that point they'd be your tenant in the meantime, and when you eventually either gave them title during your lifetime or left it to them in your will, they would become owner occupiers at that point. So it would get away from this being landlord of a vacant croft. Dividing a croft, as I said earlier, tenants and owner occupiers can apply to divide a croft. and then assign the croft or transfer title to one or both parts of the two crofts that were created. The Crofting Commission have to approve that division, though, and they can refuse the proposal to divide a croft if they think the crofts would be too small and not be large enough to be sustainable in the long term. I think I once at a meeting called it viable, but it's not viable because viable implies financial. And you could argue that maybe very few crofts are viable. But if it's that small and they just think, well, it's just hardly sustainable in the long term, then they can refuse the division. The sort of normal case officers that deal with cases as they come in can only approve a division if each croft created is no less than 3 hectares. So it's not to say that you can't divide a croft into units that are less than 3 hectares, but if any of the crofts that are going to result from the division are, and it can be, again, dividing a croft in 2 or into 3 or into 4 if it's large enough, then if any of the crofts resulting are less than 3 hectares, then the case would have to be escalated up to a higher level within the Crofting Commission, possibly even up to the Board of Commissioners before a decision can be made. And they'll very often ask ARPID to come with reports in that circumstances about how, what their opinion would be on the dividing the croft and whether it's a good idea or a bad idea and how sustainable it would be. So that's yeah. So you can divide a croft. You can apparently also divide a croft in your will, but that's covered in. We'll give you a link to a podcast called Crofting Matters about succession, which one well renowned crofting solicitor Brian Inkster with one of our colleagues, Siobhan MacDonald, did a podcast on wills and succession, and it's well worth a listen to. And Brian did cover this fact that you can, in your will, specify that the croft is to be divided and whom to go to, or who the owner occupancy of each part is to go to. But the commission still have to approve that. And if you just specify that, and usually if you're doing that, you need to have a map linked to your will that shows which bit was being left to who. But if you do that, and then for any reason the Crofting Commission refuse the proposed division, then your bequest falls. And if there was nothing else in your will, then it would then become intestate succession of the whole croft because the croft hasn't been divided, and it would be up to your executor to decide who the croft was to go to. So if you have said in your will that you want the croft to be divided and split, this bit to go to this person and this bit to go to that person, unless you have also in your will what was to happen if the commission refused the division, then you might find that the croft wouldn't necessarily go to the person you would have chosen. So it's a risky business dividing a croft in your will. I would say if you're wanting to divide the croft, it would possibly be better to get on with it and do the division in your lifetime, and then your will could either leave the two separate crofts that you've divided it into, or 3 separate crofts, whatever, to specify in your will who that croft is to go to. Rather than trying to have it covered by your will. Another thing that comes up a lot is if there's a house on the croft, if the house has been decrofted, then it's no longer part of the croft and it's not affected by either a lifetime transfer or a will. So you just ignore the house, and if you still own the house and you want the house to go to a different person from the croft or to the same person from the croft, you just specify that in your will or do a lifetime transfer of title to the appropriate person. If not decrofted, then the house will pass, and you do an assignation in your lifetime, or it's left in your will that so and so will succeed to the croft, then the house will pass with the croft to the new tenant or owner. Now, So your options are you could consider decrofting the house first during your lifetime, and if then you're once it's been decrofted, you're free then to leave the house to a different person from the croft. But if you wanted the croft house, if you wanted the house to remain part of the croft, then you could perhaps go, but you wanted to be able to use the croft during your lifetime, then it's probably a matter of going to your solicitor and getting the solicitor to draw up a lifetime rental stroke occupancy agreement, so that you have the use of the house as long as you need it. But the house would then the house effectively is part of the croft that your successor, that you've passed the tenancy on to, or if it's owner occupied, then it's actually the person you've transferred, if you've transferred title to the whole croft to them. I mean, if you were owner occupier and the house hadn't been decrofted and you transferred title to the croft but not the house, then effectively you're making you and that person landlords of a vacant croft because you both own separate bits of the croft and the croft hasn't been divided first. So that's something to be wary of doing. Wills. Oh, sorry, that jumped on. Oh no, it's okay. I thought I jumped too. So if you're not going to deal with succession during your lifetime, it's very important to have an up-to-date will. And you know, things can change, circumstances can change. Perhaps even the person you were planning to leave something to has deceased themselves, so you need to make sure you update your will whenever that's required, and make sure you have a proper up-to-date will. But if you are dealing with succession in your lifetime, then make a start as soon as possible. And even if you are doing that, make a will, because you never know what's round the corner, you know. So I would definitely say to everybody who has a croft, if they either own a croft or tenant a croft, they should have a will that covers what they want to happen to that croft on their passing. There's a link here to a document prepared by Anderson Strathern with their top tips to do with crofting succession in general and wills in particular. So I would say we'll put that link out with the emails at the after the webinar. So that's something that's well worth a read as well. And then I did refer to Crofting Matters. There's regular new episodes come out quite frequently, and it covers a broad range of crofting issues. You can just search for Crofting Matters on your normal, wherever you would listen to a podcast, be it on Podbean or Spotify or whatever. You can usually find Crofting Matters. And if you look for the episode from the 31st of August 2023 with Brian Inkster and our colleague Siobhan MacDonald, that's quite a good one and well worth a listen to on the lowdown about crofting wills. And Brian goes into this possibility of dividing the croft in your will and the risks associated with that. So I'd urge everyone to have a listen to that.
It comes out in that podcast very much how important it is if you are getting a solicitor or a lawyer to advise you on any aspects of crofting succession, and especially crofting wills, that you do make sure, and you make very sure, that the solicitor does have extensive experience in crofting regulatory issues. It is not enough for them to tell you that they live in the area or that they have some experience. You need to have a reasonably good track record, and it's always a good idea to ask around and see how other people have got on with this kind of work, because it can be wildly variable.
Yeah, and in that podcast, another thing Brian pointed out is that Shetland is sometimes a little bit different to many other crofting areas in relation to hill shares. If your croft has a hill share in Shetland and you buy your croft, then probably more often than not, the landlord will also have sold you the heritable right to graze that share in perpetuity. So you're not paying a rent to graze your common grazing. You just have the right you own the right to graze that common grazing. And that would then pass with the croft. If you then passed on the ownership of the croft, the heritable right to graze the common grazing would normally pass with the croft. The if you buy your croft and the landlord hasn't sold you the right to graze the common grazing, which I believe is more the norm in areas other than Shetland, then you are owner-occupier of the croft, but you're still effectively tenant of the hill share. And in that circumstances, the hill share is deemed to be a separate croft. So it is what the Commission call a deemed croft. And you need to remember when you're drawing up your will, or in terms of doing lifetime transfers, or even an executor dealing with an intestate estate, they need to be aware that the tenancy of the hill share needs to be assigned separately. It doesn't automatically go with the croft. And the same can apply to apportionments. If you have taken in an apportionment after you bought your croft, then you don't necessarily you don't own the solum, the soil of the apportionment, and in that case you are in law deemed to be tenant of the apportionment, and the apportionment is another tenanted deemed croft. And again, you need to deal with the succession to that tenancy in your will, or to do a lifetime assignation of that tenancy. So it can cause a lot of complications if there are deemed crofts involved. And where I think since the crofting register came on the go, in Shetland, folk are and their solicitors are more aware of this, and hopefully not ignoring it or neglecting to deal with it in recent times. That we find regularly when we're looking to register crofts and do transfers for folk, that there is a deemed croft that was never transferred to them and is still sitting in the name of the previous generation or the previous occupier who sold it, who sold the croft, but didn't assign the deemed croft tenancy or the deemed croft hill share. So that can cause no end of problems.
Graham, there's a wee question that's come in just now about shares in a common grazing. There's someone who is struggling to leave their shares in a common grazing in their will because the common grazing is not regulated. It was included in the Register of Crofts, but now seems not to be there. What would that person need to do?
I think I don't know if the Karen or that want to chip in, but I think they would need to get in touch with the Crofting Commission and see what can be done. I know that we have in Shetland there's quite a few unregulated or common grazings, but usually they still do specify which crofts have a share on the register. But I have seen one where it just said that the croft had an interest in the common grazing, but there was no specification of what the extent of the share was, and if you went to the common grazing list, there was no lists of crofts against that common grazing, which you usually get with most common grazings. So I would think it's quite tricky, that, and I think it would be a matter of having to liaise directly with the Commission to see what could be done.
Yeah, just to jump in, I'd say hopefully we'll share our details, but there is a grazings team. There's a grazings officer for majority of the 14 years I've worked for the Commission, and I would say there's a lot of unregulated grazings, but we should we can check our historic files and we can check the records to see if we can find information about that. So certainly put in writing what as much as as possible. If you've got your croft, and the grazings team will look into that. If it is unregulated, but a few more of the shareholders, the best thing to do would be to form a grazings committee to then get regulations in place and confirm your shareholders, so then that it will get updated on the Register of Crofts. And then down the line, if there's people questioning whether you share or you don't, it's in black and white on the Register of Crofts, and it's all been agreed with the landlord and a grazings committee. So I would say we'll share our details, and if you've got information, we can certainly pass that on to the grazings team.
Super, thanks, Lynn. There's also somebody asking if there is an official list of recommendations for solicitors with crofting knowledge. in regard to making out a will or doing crofting regulatory work. And I would say that nationally, no, there's not at all. And that's why it becomes quite problematic to check whether a lawyer or a solicitor does have crofting regulatory experience, because you are kind of taking their word for what their track record is. We find locally here in Shetland that probably the best way to go about it is to speak to people who have done crofting regulatory work, ask them who they dealt with, ask them how they found it. You'll get quite a clear picture quite quickly. Speaking to a variety of people, go to your local agricultural show, have a chat with various people who are there, and you'll get quite extensive information quite quickly, and usually quite resounding answers quite quickly. But there aren't really official bodies who can give you that, because you get into the territory of defamation of character and it not really being particularly fair. But ask around would be our best advice.
This is not all the questions for now.
It's not all the questions, but there are.
Graham, there is a question near the beginning, which I think you did answer to some extent, related to wills. Can you ask for a croft to be left to a single person, and then for that croft to be sold and the proceeds to be split between 3 offspring?
Yes, I think, well, I don't know. I think that's more a lawyer's question, because your will could only really deal with the transfer of the tenancy. I'm not sure what onus you could put on the new tenant to sell it, the tenancy. So I think you'd have to consult a lawyer on that one. You know, as long as everybody is cooperative over it, shall we say? You know, that if there's 3 potential beneficiaries and none of them are interested in getting the tenancy of the croft, and they all just want a share of what it would be worth, then and they all cooperate, then there's nothing to stop that happening, I don't think. But whether you can put an obligation in your will for that to happen, I'm not so sure about that. That I think you'd have to discuss with a solicitor.
Graham, could a solution in that case be similar to the case that we dealt with, where a tenant bought their croft but nominated a party to be the new owner occupier? If it was dealt with in the person's lifetime,
yes,
they could sell the tenancy,
yes,
nominate a new owner occupier, and divide it in that way, but it would have to be done in their lifetime.
Yeah, but again, once they transfer title to the new person, is there any legal obligation on the new person to sell that and to split the money, or?
No, I meant in the sense of to split the money in the lifetime.
Oh, I see what you mean.
Without
I
it
see.
being in a will.
So yes, so they're transferring the ownership or the tenancy to a third party, and then just leave in their will that they're dividing the money. Yeah, I suppose that could be potentially, a way to do it. I think Frank's got his hand up, Frank Robertson.
It's compensation to outgoing tenants.
Yes.
In my past life, I was a chartered architect and had the ability to sign financial documents and contracts and goodness knows what else. And people came to me and asked me to value crofts for them.
Yes.
Which I did. I was born and brought up in Crofts, and I actually made my living going through college by putting up fences in the summertime and this kind of thing. So I knew the land, I knew everything about crofts, and I was able to, survey crofts and come up with a reasonable figure for compensation to the outgoing tenant.
Yes.
And the rule of thumb at that time, when I took some advice from the Commission's Clerk of Works, was the compensation due to an outgoing tenant was the improvements that they had made in their lifetime to the to the land and pertinence of the croft. Depending whether they were owner occupiers or not, the croft house usually had a nil value unless there was quite a lot being spent on it. And so I valued several properties with very, very old croft houses on them and concentrated on the fencing and improvement of the land and on the apportionments. And in some occasions, you had to look at the deterioration of the fencing and the question of what the incoming tenant would be faced with. So I was dealing with, at that time, relatively modest sums.
Yes.
Now, what we see now, and there are, and I've come across it, there are valuers who do not understand Crofting law, do not understand the question of the use of land and that kind of thing, and they put unbelievable values on the house and the house site, even and on occasions when there's no title to the house site. And so the outgoing tenant is obviously delighted. They get their 50 or 60,000 or sometimes more. And the incoming tenants, who are usually young people, have a struggle paying it.
Yep.
So it's this question of concept of valuers.
Yes.
And it's something like we mentioned the lawyers who don't understand Crofting law, and I'm come across them in my time, well and truly.
I think what you're saying, Frank, is very correct in terms of the Crofting law. In practice, though, as you say, the crofts can often be valued much higher. The tenant, say in a tenant situation, tenant crofter, what he's renting from the landlord is the bare unimproved croft, all the tenant's improvements, not just his improvements, but the improvements over the generations belong to the tenant.
Yes.
And he will have inherited a certain amount of that improvement, but as you say, if he's carried out further improvements himself, taken in an apportionment or whatever, that would add to his value. And you would hope that if crofts were being passed on within the family, then that would be the sort of value that folk would be looking for. But if they, if nobody in the family is interested in taking on the croft, then obviously they're looking to maximize the potential value of the assigning the croft for compensation, as it's called. I mean, there was a period where, if you go back to before 2010, before this owner occupiers getting the eligibility for the crofting grants, then there was a very much an argument that crofters getting a croft would almost prefer to be a tenant than to get the ownership. And so in reality, there were folk paying as much for a tenancy as they would as if they were buying the croft, because they then thought, well, as a tenant, I'm automatically eligible for the grants, and I can get all the fencing grants and whatever, or reseeding grants I need. So it's worth my while paying as much or more for the tenancy as it would be as if I was buying the croft. So effectively, the compensation for a tenancy moved to the point where it was whatever the croft would have been worth had it been owner occupied. And since, though, the definition of the owner occupier and the owner occupiers get the same grant, I would say folk now would prefer to be an owner occupier than be a tenant. And so I think there is, more recently, there's been a discounting of tenancies compared with the ownership of a croft by several thousand, because if you became the tenant, you wanted to be the owner occupier, which a lot of folk would prefer, you would have to pay 15 times the modernised rent to the landlord, and you'd have to pay several £1,000s of legal expenses to be able to take title to the croft to become owner occupier. So folk are probably knocking 5,000 or more off a tenancy valuation compared with where that an owner-occupied croft being offered for sale. And that's just the reality. I know it's not necessarily what's due in legal terms, in terms of compensation, but it's what folk will offer for tenancies if a tenancy is put up to the highest. But Lynn, have you any comment from the Commission's end, or Karen?
I mean, when it's a succession within the family, that's one
Yeah.
that's one thing. But when it's an assignation outside the family, that's
Yeah.
what I've come across.
Yes, I mean,
With this, silly money.
yeah, it only goes to just really whatever if they'd owned the croft and we're selling the title to the croft, then
Yes.
the tenancy will probably go for a bit less than that, but will be
Yes.
not that far short of it. It's where it's passing within the family that's a bit much to ask. But then the question again, which might be more for a solicitor than me, would be where somebody has passed on and left a tenancy as part of their estate. How do they value that? And the tenancy is going to a family member. How do they value that tenancy? Because they still have to put a value on that tenancy to get the confirmation of the person's estate.
And also the capital gains.
Yes, that's right. Yeah. Or inheritance tax if they're into that sort of brackets. Yeah.
I think what we're seeing is a huge demand for crofts in a way that was possibly unprecedented before. And with the demand, the values are going up even for a tenancy, not just an owner-occupier croft. I don't know if Karen, you want to give any anecdotes of some of the things that we're seeing from our side of it.
I suppose the difficulty that we're seeing at the moment is people being able to afford to get into crofting. So, like we spoke a moment ago about selling tenancies, as I'm sure you're aware, you can't actually borrow against a tenancy, so you can't borrow money to buy a tenancy. So it really is a kind of market for those that have, at the moment, unfortunately, the cash to stump up to buy the tenancy. As an anecdote, at the moment, I've just purchased it. Well, I'm in the process of having a croft assigned to me that I've purchased, but it's been a process that's taken about 3 years because the crofter that died didn't leave a will, and the croft house was still part of the croft, so that had to be separated. So if this isn't done properly or carefully and isn't thought through, it could leave quite a mess behind for folks. So it's just, I think our message is just to be proactive and to actually take some action while you can oversee it, if that makes sense. That's what I would maybe say.
Yeah, that's a very good point. And it's not just the tenancies where if the house hasn't been, if the house is still croft, then and you're offering an owner-occupied croft for sale, then the people going to make you an offer can't borrow against the croft or the house if the house hasn't been decrofted. So if you are really looking to sell a croft which has a house on it and sell the house with it, you really need to probably get on with decrofting the house site so that the potential buyers can borrow against the value of the house, which is very often, 70, 75, 80% or more of the total value if it's a reasonable house. Depends on the house, of course, but whereas if you haven't decrofted the house, it might be a house that's worth an absolute fortune, but if it's sitting on croft land, only those who have that money sitting in their bank account will be able to make you an offer because they won't be able to get a mortgage on it.
There's a slightly different question that's come in. Is a croft house safe from financial assessment for care home costs whilst the house is not decrofted?
I think it makes it more difficult for the local authority. I'm not sure if it's entirely safe, and I think they are actively pursuing ways around it, and I'm not sure whether they're going to succeed on or whether they have succeeded or whether they will succeed on that. So I don't think it's necessarily a guarantee, but it does, where the house isn't decrofted, it does make it more difficult for the local authority to take the value of that house into account to pay for care costs.
So I don't think we want to be proactive that one. Deal with your affairs at an earlier stage so that you don't end up in this kind of situation. But yes, I would agree with what you said. It's not 100%, but yeah, the earlier you deal with these things, the clearer that should be.
Mm-hmm.
I think we'll maybe crack on with the last few slides of your presentation, Graham, and then
and I think this is practically the last slide, I think. So it's just as well as wills, folk need to be aware that it's probably advisable to set up a power of attorney, so that somebody, if you're become incapable, somebody can take over responsibility for dealing with your affairs. You know, if you're unfortunate enough to develop dementia or something like that, it's by the time you're diagnosed, it's too late. You cannot, if you're not mentally capable at the time, you can't set up a power of attorney. So it's something that's well worth looking at earlier, at the same time perhaps as you're doing a will. And it does take quite a while to get a power of attorney in place. Myself and my wife, we updated our wills back in January, February, and got the solicitor to set up powers of attorney from one to the other, and to our children if the other wasn't around or capable. And it took from February to August to get the court approval for the powers of attorney. So it was a good 6 months to get approval of a power of attorney. So I think you know, the sooner you tackle that side of it as well, the better, I would say.
I think it's also something that people tend to think about writing a will or getting power of attorney in place when they are of a certain age. I think a lot of people maybe start only kind of talking about wills and power of attorney when they're older, and it's absolutely not something that should be left until you're older. It's something that, I mean, my husband and I have it in place. It's something that if you have property of any kind, you should be thinking about from as early as your late 20s, early 30s. It's not something that should be left until later in life, because none of us know what's going to happen. Tragedies befall people all the time. People drop dead of heart attacks at 30 years old. It's really something that should be done as soon as possible, and it should be considered just as a practical question around what would happen if the worst should befall us.
Yeah, my wife and I, we updated our wills this year, but we have had wills in from, well, as soon as kids came along. So Louise is 21 now, so we've had a will for over 20 years, but it was well out of date and had things in it that no longer applied, and so we had to get it updated. It was really only when we were updating that will, and as you say, Ursula, we were getting a bit older, that we decided we needed to have powers of attorney in place as well.
you, Graham.
The cat fits. Yeah.
Chris Mitchell on the chat is just pointing out that OPG do have an expedited service for powers of attorney if it's necessary, but it would really be better not to leave it until you need an expedited service.
Yeah.
It's another thing that people tend to get. These are all difficult conversations to have in a family, because essentially we are talking about death. And it's sometimes difficult to get everybody who needs to be there around the table. It's sometimes also very emotional when it doesn't necessarily need to be. It can be useful to have an impartial mediator. It can also be useful to just set things out really clearly, especially power of attorney. I've heard of cases where people have had all kinds of drama in the family because siblings have argued around, well, why have you asked her to be your power of attorney? I'm the one that did this and I'm the one that did that. It's not an emotional thing, it's just a practical consideration, and that's how it needs to be dealt with.
So I would say, you know, before you can write your will, you really need to know exactly what you're dealing with in terms of making sure you've gone on the registers and established, are you, you know, is it one tenancy? Is it two tenancies? Is it three tenancies? Are there any deemed crofts? Is there any, and in terms of the deemed crofts, both the hill share getting separated from the a crofting tenancy, or apportionments becoming a deemed croft, they won't necessarily show up. You need to perhaps go back if you have, for example, bought your croft you need to go back to your disposition that was created when you bought the croft and see, does the disposition state that you bought the right to graze the common grazing or not? And if there is a common grazing right and the disposition didn't say you were buying it, then as I understand it, the legal position is you are still tenant of that grazing right, and it would then need to be created on the Register of Crofts as a new deemed croft, and it might or might not be there. And the same can go with apportionments that have been taken in perhaps after you bought your croft. Then you don't own the solum of those apportionments, and so that should be a deemed croft, but it might not, and very often is not on the register, and you have to approach the Crofting Commission to explain that this is missing from the register, and they will create a new entry for that deemed croft on the register. And a question we get asked a lot is when folk have say an apportionment that's a deemed croft is, do I have a right to buy a deemed croft? And the stock answer seems to be legal opinion is divided and it is yet to be tested in the land court. So in most cases, landlords, or not in most cases, but in a lot of cases, landlords will refuse to sell you a deemed croft other than at a full market value, rather than at 15 times the rent that goes with that deemed croft. So yeah, so deemed crofts can cause a lot of complications. So you need to sort of make sure whether you are in that position where there is a deemed croft that might need to be dealt with as a succession to the tenancy in your will, or an assignation in your lifetime. And too many times in the past, the folk have transferred their crofts assuming that the deemed crofts have gone with it, and they haven't. And even the wording of some of the I've seen dispositions where it said that somebody was selling their croft on their apportionment, but the apportionment was never theirs to sell, because they'd taken in the apportionment after they'd bought their croft. And so that was a deemed croft, and they were only tenant of that apportionment, and that apportionment should have been assigned. But the disposition actually said they were selling the croft on the apportionment, but it doesn't have any legal standing, that. So there are complications you need to watch out for. And so before you even write your will, you really need to get a really good handle. If you only have one croft and you know you're tenant of it or whatever, and there's no apportionments, and well, that's relatively straightforward. But if you have umpteen crofts, and often folk, maybe, you know, we've had folk who thought they had 2 crofts and it turns out they have 5, and they maybe have a deemed croft for by that as well. You know, you need to really get to the bottom of everything first before you can write your will. But don't leave it off. Get on with it.
I'd underline that and say that, I mean, 95% of the people who come in to do croft and regulatory work with us, they think they know what they want to do. And then you sit down and look at it with them, and actually what they need to do is 7 or 8 other things that they didn't realise they needed to do, because they didn't know that half their house was decrofted and the other half wasn't, and they weren't owners of the apportionments, and the hill shares had actually got separated somewhere along the line. There are all these things that come out of the woodwork just when you start looking at it.
Mm-hmm.
And that's yet another reason why you have to get onto it when it's early days and you've got plenty of time to look at all of these things.
Yeah, that house site thing crops up a lot. A lot of times, folk will decroft a bit of ground with it because they're building a new house, and they apply for planning permission, and there's a site map done of the bit they're going to build on and the bit they want to decroft, and then the builder comes on site and he says, well, if we can just turn it 25 degrees and move it back 10 meters, it'll be a lot better site for this reason, for perfectly good reasons. And so they agree to that with the builder, and then they forget that they've now built on bits that haven't been decrofted, and they have to go back and decroft the extra bits. They can't put back to the croft any bits that they mistakenly or would have rather they hadn't decrofted, but if they want to be able to give a clear title to the house, then they need to decroft the extra bits that they now have enclosed. Or perhaps over the years they've enlarged the garden or built a shed, a garage or something like that, then it might or might not be within the area that was decrofted. So yeah.
And in the interim, they may have put in a new tenant to the croft who has now registered it, and it's just a lot of work.
Yeah. And we've also, you know, we have regularly ones folk come in and you sort of end up saying to them, well, I wouldn't have started from here. in that they've done something along the lines in terms of passing the croft down a generation that is just going to leave problems to sort out. That maybe has created because we had some folk in recently. They'd left half of croft to each of their sons, and then that made the sons landlords rather than owner occupiers. And and then as landlords, they're not able to apply to divide the croft, so it just causes no end of problems. So start early, and if you're not sure, take some advice early on as well.
I think one of the things from the commission side of things, what we've seen is, and I'm not sure if it's a cultural thing, but when you talk about leaving things to family members, you feel you're doing them doing a good deed and setting them up well, but you need to have we would say you need to have these discussions with them, because if they're not interested in crofting or they don't want to be a crofter, you don't want to leave them with the burden of, oh, I've been given this croft, but I live in, I don't know, London. We have crofters who have been left crofts who live in New Zealand. So
Yes.
it's like, have these conversations with your family members and find out, do they want to be a crofter? Do they want the croft? What do they want to be? Having these discussions is really important, and the earlier the better.
Yes, I mean, if they're living away and have no intentions of coming
Yeah.
back to the croft, that just is a recipe for disaster, because when each year they'll be asked to complete the crofting census, and they're asked to say whether they live within 32 kilometres, 20 miles of the croft, and if they aren't, then they are in breach of their crofting duties, no matter how well the croft's been looked after. If they're an absentee in effect, then they are in breach, and the commission could ask them to come up with proposals as to what they intend to do with the croft to pass it to somebody who is living within 20 miles. So yeah, so there's no point in leaving something like that to somebody who's not interested.
There's another question come in. If a bit of the house is still on the croft and the rest is on decrofted land, can you apply to decroft the tiny portion? Does the Crofting Commission allow this?
Yes. Simple. Yeah.
We both answered that one at the same time. Yes.
Yeah, that's not a problem. It's just a bit of a rigmarole, and it does take a few months for that to go through, sort of thing. So, if you're one slight complication can be, and which can make it more expensive, is if it's a tenant that's doing that. Then when a tenant applies to decroft, what's granted by the commission is an advance of purchase decrofting order, and there then has to fully effect that decrofting order. There has to be a transfer of title from the current owner, the landlord, presumably, to the tenant to fully effect that decrofting. And any transfer of title, no matter how small, is going to have a legal cost that's quite significant relative to the bit of ground. You're talking several £1,000s to get a transfer of title and do a land registration. So if it's a very small bit, that could prove quite expensive.
There's a question in from the same person. If I have a will from when I was in my 20s, but before I had a croft, do I need to annul the old will before getting a new will?
I think just writing a new will effectively annuls the old will. So as long as the new will is properly drawn up and witnessed, signed and witnessed, then I think that would take precedent over the old will, is my understanding. So yeah, I think it's just a matter of drawing up a new will.
Super. There's another question here that's not necessarily entirely succession related, but if I have a croft under short-term let from an owner-occupier crofter, my mother, am I entitled to the new Croft House grant from Rural Payments?
Yeah, I don't think so. Karen or Lynn? No, don't think so. No. No, I think it's only. I think you get the CAGS grants in terms of croft improvements, fencing, drainage, reseeding, croft buildings, but you don't qualify for the housing grant unless you're either the crofting tenant or the owner-occupier crofter. Going to something about the short-term sublets and short-term lets, which might be worth mentioning. It was something I had to go and get clarification on. I was aware that if you're a subtenant and the full tenant passes away, then effectively the subtenancy comes to an end on their death. But you can apply, as long as you do so within a month, you can apply to the Crofting Commission to remain in occupation of the croft for another 12 months. So that's something to be aware of. Short-term lets, I think, is slightly different in that, again, the short-term let comes to an end on the death. I mean, the subtenant also, the subtenancy also ends on the death of the subtenant, as well as on the two full tenant. And in short-term lets, it comes to an end on the death of the owner-occupier or the short-term tenant. And I don't think there's the same, as I understand it, there isn't the same option to apply to remain in occupation for 12 months. It's more down to whoever succeeds to ownership of the croft in conjunction with the short-term tenant to advise the commission on what's happening, whether they are going to whether the short-term let is going to continue with the new by the new owner, be honoured by the new owner.
If there are other questions in the chat that we haven't dealt with, or that you feel that we haven't dealt with, please pop them in the chat again, or pop your hand up and we'll deal with them. Graham, did you have anything else?
Is that Frank got another question? Need to unmute yourself again, Frank.
I'm trying to unmute him.
A question to Graham.
Yep.
Have you come across the term outsets and outruns?
Yes, I have.
Because I have lots of old maps, the original maps, which were carried out at the end of the last century.
Yeah.
And it's shown for certain townships, it shows outsets and it shows outruns.
Yeah, I have come across them, and it seems to be, I'm not sure when, there was also run rigs. There were some crofts with a share in the run rig areas. And I'm not sure when official apportionment of run rigs came into being, but I have come across ones where some of these outruns, outsets, or run rig areas were officially apportioned to different crofts. And if you are registering those crofts, you need to deal with them as apportionments. So they need to be mapped in a different color to show them clearly as an apportionment. And you have to go strictly with the apportionment order, because I had one where there was apportioned run rig where two individuals had swapped bits of their apportioned run rig to make it more convenient to fence them in sensible blocks. But you couldn't register that because it hadn't been done officially. They had just unofficially swapped bits. So we had to go and register their crofts with the original apportioned run rig. A lot of the outsets and outruns I found seemed to be, a lot of them were divided up before there was ever official apportionment. And I've been told in that case just to register them as part of the croft, because there is no sort of official apportionment order or anything showing, but the folk have been, occupying that bit of ground along with their croft for the last 40, 50 years or more in some cases. So they've just basically told me to ignore the fact that it's outset or outrun and just to register it as if it's part of the croft.
Right. I mean, I've come across outruns that have been there since 1870.
Yeah. So it was actually, you're talking about going back almost before the Crofting Commission existed, and yeah. So there's no official, there can be no official document saying what was divided to that croft. But if it's been accepted that long by everybody, then I think it's just quite reasonable to treat that as if it's part of the croft and to register it with the croft.
And I also have a very interesting map, which is the Roderick coin map of 1867, which was setting off all the whole land for all the various different landlords in San Sebastian and Walsh and Sanders.
Oh, right.
And it's literally hand-drawn and hand-coloured.
That's super
Scots of Melby and Humphreys of Raywick and etc.
That's very, very interesting. There's another question come in. There's a lady who says she has a very simple will created last year, and her two children will share in the value of her entire estate, equally retaining the bits that they each want and selling the rest. Son is not interested in the crofts. The daughter would like them. Plenty of value to allow this to happen. does she need to amend her will to specify the fate of the Crofts?
I think it would be probably better if the will specified that the Crofts were to, I think the solicitor would be able to word the will that the Crofts were to go to the daughter, but that would be part of her share of the overall estate. And I think that would be clearer because if the will doesn't specifically mention the Crofts, then as I understand it in the Crofting Acts, that's intestate succession, which is then down to the executor, and the executor could do something completely different. So I think it's probably better if the will did, if she could get a codicil or an amendment to the will to specifically say that the Crofts were to go to the daughter as part of her share of the estate that she's
Or
leaving.
depending on her circumstances, I don't know how old her children are, but if they're old enough, transfer the Crofts to your daughter now, and then your will, you don't have to deal with that issue, and also in a way you're doing a living succession, so you can still be there.
Yeah, but she'd have to
Yes.
specify in her will in that circumstance that the son was to get a bigger share out of the residue if the Crofts were sort of part of the value that her daughter was getting.
Right, I think we are just starting to lose a few people now, but perhaps people haven't had their dinner because they didn't have time to time to get anything to eat before we started.
That's me for one, yeah.
But that has been a really interesting session. For everybody, we will ask you to fill in via email, we'll ask you to fill in just a feedback form to say if you found this useful, helpful. We would ask that you please do that because this is funded by the Farm Advisory Service through the Scottish Government, and they are also always very keen to know that we are doing things that are actually useful to people and helpful to people. It's also a good opportunity if you have other things that you would like the Farm Advisory Service to be doing, pop that in there on the feedback form, ask for the things that you would like to see sessions on, because that helps us to plan for future training sessions. We will also send you the link to the recording if you want to watch it back. We'll send you a copy of the slides as well. We'll send you copies of all the sort of useful links that we've talked about. We've got the link to top tips for crofting wills. Perhaps one thing we didn't say about crofting wills is that it is always better to specify the crofts by name and by register number actually in the wills, rather than saying, and I leave my crofts to, because that can be debated and questioned. So it's good to be as specific as possible, but we'll send you out the links to a lot of the stuff that the Crofting Commission provides as well. They've got a page of fantastic useful links, including the Scottish Land Matching Service, their own downloadable leaflet on succession and how to go about it. You can also remember, if you have questions after this that you would like personal responses to, the Farm Advisory Service does have a one-to-one helpline, an advice line, and you can get a free half-hour advisory call by calling 0300 323 0161. That is 0300 323 0161. And that, of course, is not just questions on succession, but that's any questions related to any farming or crofting issues that you might want to discuss. There's lots of resources on the FAS website, of course, and also through the Farm Advisory Service there are there's funding available for what we call specialist plans. And one of the types of specialist plan that you can apply for is a succession planning specialist plan. Which I think if you've taken one thing away from tonight is that it's complicated. So there is also funding there to support people with navigating this and getting that specialist help that's often necessary. But thank you very much to Graham, and thank you to Karen, and thank you to Lynn, who've done a sterling job of responding to questions on the chat as they came in. And thanks ever so much to everybody for coming.